Good afternoon and welcome everyone. This is the second time we're recording this webinar. My name is Jackie Broman, I'm from TBA Law, and we are hosting a guest webinar today. Your rural business may be more valuable than you think. And our guests are Victoria and Carolyn from Houlihan Squared. They are patent and trademark attorneys. So Dr. Victoria Longshaw works out of the Melbourne office of Houlihan Squared. She is a solicitor admitted to the Supreme Court, but she's also got a PhD in biochemistry. And Dr. Carolyn Rolls, also from the Melbourne Houlihan Squared office, again, also solicitor admitted to the Supreme Court, but PhD in inorganic chemistry. So very highly educated, really, I guess, specific interest in terms of patents and the expertise there that you can provide. But I'm really keen to hand over to you again and run through these fantastic case studies that we have that lets rural businesses know all the various aspects of what they're producing that can be valuable and worth protecting, let alone what they could earn more income from. So I'll hand it over.
Great, thank you, Jackie, for the awesome introduction there, and thank you very much for making us so welcome and letting us provide this information to you and anyone who would like to find out more about their intellectual property. So our presentation is going to be about the intellectual property aspects of your business. We're quite passionate and we care a lot about people realizing what is intangible assets in their business that are worth protecting and can provide a lot of value to their business. So I will hand over to Carolyn to explain exactly why we're here.
Yes, we're certainly enthusiastic about IP. We really enjoy talking to people about their businesses and helping them to identify the IP in their business, or more importantly, identify the value of the IP in their business. Unsurprisingly, most people focus on the tangibles of a business, the things they can see and touch, the buildings, the equipment, plant and products and the like. Intangibles such as IP can often be overlooked. So what we'd like to do today is to firstly explain what the term intellectual property or IP covers. And sometimes we surprise people by what we have to say about that. Then we'd like to firstly show you some ideas to consider when making your decisions regarding IP. We'd like to illustrate how IP can be used as an asset and point out possible pitfalls and traps that could stop you extracting value from your IP, or things that might actually give a free kick to your competitors. Some IP may be extremely valuable, but IP protection likewise can also be expensive. So cost-benefit analysis is very important, as it is with all aspects of a business. We hope that we can help you, at least in a small way, to make informed decisions that benefit your business. And on the other side of the ledger, we're not here to sell you stuff. We just hope that we'll be able to help you make some better decisions.
Yes, so we tend to make sure when we have a look at people's trademarks or ideas for patents, we'll tell you straight whether we think this one is actually going to be more money than it's worth, particularly if your trademark is, you're going to end up having to fight quite a bit for it. So we do have a bit of a saying here that nobody likes to tell you when you've got an ugly baby, and we'll tell you if you've got an ugly baby and it's going to cause you problems. So there are various solutions in how to address difficult aspects of things, but we'll tell you straight if we think you need to make different plans and what we think you should do about it. So to introduce our firm, we have a few offices. Our head office is located in Melbourne. We have offices in Singapore and Malaysia too, as well as New Zealand. These are our people on the ground. Most of the decision making and advice and handling of files is centralized in the Melbourne office. So our founders are Elizabeth and Michael, and they didn't want to go with anything so boring as Houlihan and Houlihan, so they went for Houlihan Squared, both having technical sort of chemistry backgrounds. Elizabeth is an inorganic chemist and Michael has a background in winemaking, and the pair of them actually enjoy beekeeping. So they have become quite expert in keeping bees, and we often get honey, not as often as we'd like, but some pretty good honey. Nigel is a partner also at the firm, and his background is biochemistry. He loves his fishing. Paul, he is has a background of biochemistry. He also handles a lot of the software aspects, software sort of methods in the patent area. Jim is an organic chemist, and he handles a lot of the sort of pharmaceutical kind of aspects. That's me, and Carolyn, that's your mugshot on the end there.
That's me.
Yes, so all of us are, I'm in the biochemistry side and Carolyn's in the organic chemistry side. And we all have very sort of specialized backgrounds, but we've also had to train in a sort of generalist area as well. So we all handle trademarks, copyright, as well as the sort of contractual aspects of IP business.
Yeah, so the obvious place to start today is with the question, what is intellectual property? Well, as a general proposition, intellectual property is the product of your intellect and your creativity. This slide lists the types of IP that you're most likely to encounter, or the types of IP protection. There are others, but they're not as common, so we won't deal with them today. But probably the types that people are most familiar with are patents and trademarks. Patents cover inventions. So a patent gives an invention owner a monopoly over exploitation of an invention for usually up to 20 years. That's the type of protection that you have to apply for, and it applies to inventions. Patents protect inventions in terms of their technical functionality. And as patent attorneys, we think of inventions as solutions to problems. And you can't patent a mere idea. The idea needs to be reduced to practice in a technical sense. But it could be in the form of a product that you can pick up and handle, such as a new device or a machine or an apparatus, or it could also be a method or, say, a process for making the product. And there are some other slightly surprising sorts of patent protection, such as patents for software. But that's a little bit esoteric. We won't be delving into that. What we will be concentrating a bit on today are trademarks, both registered and unregistered trademarks. When you think of a trademark, think of an indicia that distinguishes the goods or services of one trader from the goods and services of another trader. Could be a word, could be a logo. In fact, it can even be an aspect of packaging, or a colour, or a sound in certain circumstances. If you see the Ford logo on a motor car, that's an extremely powerful trademark that will immediately make you think of the right producer. And trademarks can be extremely valuable. People sometimes ask us what are the most valuable trademarks in Australia, and they're the ones that belong to people like the telcos, like Telstra, and the banks, and the big retailers such as Coles and Woolworths. They're memorable, they're instantly recognisable. So, for example, nobody would mistake the black and yellow Southern Cross arrangement that the Commonwealth Bank uses from the red W that Westpac uses, from the blue ANZ logo. They clearly distinguish each of the bank's businesses. We're also going to touch a bit on design registration. Design registration covers the appearance of a product, not how it functions, not the technical aspects, how it looks, its shape and configuration, or pattern or ornamentation as applied to the product. We'll also touch on copyright, a very powerful form of intellectual property protection that doesn't require you to file an application, as does a patent or a registered trademark or a design. Copyright exists in certain types of creativity from the moment that they come into being. And we're talking about things like written works, literary works, visual works such as photos, paintings, artwork, sculptures, even things like screenplays, the way things are organised in a book. There's a whole bunch of different types of copyright protection. Pardon me. We're also going to touch on confidential information, which is basically anything that you know of that your competitors would like to get their hands on, such as your client list, your supplier list, how you run your processes, all those day-to-day things in your business. We'll touch on get-up, or the appearance of a product, or, for example, if you were blindfolded and dropped in a store and they whipped the blindfold off, if it was a McDonald's store, you would instantly recognise it without even seeing the McDonald's logo. It's the get-up of the McDonald's stores that forms a huge part in that corporation's value. And finally, we'll touch on plant breeders' rights. That's a sort of plant patent for a new type of plant that is stable and reproducible, and it can give you a monopoly not only over the plant, but the reproductive material. So, having touched on some key types of intellectual property, I'll hand over to Victoria.
So rather than running through a dry and boring list of cases and things, we thought we'd come up with our own cases and our own people. So we've come up with an illustration sort of case, the tale of two olive oil producers. These two characters are both have olive oil production companies, and they both have a different approach to how they protect their IP. So now we'll introduce, first of all, Mr. Plan Ahead, and then later, Mr. She'll Be Right. So let's have a look at what Mr. Plan Ahead has currently been doing. Mr. Plan Ahead has a family farm and an olive oil production business, and he has been working on the farm for some time, using his family's old methods of production of olive oil. But in doing so, he's come up with new improvements to that method. He's updated those methods. He hasn't yet sold any of the oil that he's made according to this new method. He's still experimenting with it and testing it out. He's also designed a new bottle, so he's quite a creative chap. He's come up with a new bottle with a different shape and a new pouring dispenser, you know, one of those fancy pop-up things. He has been experimenting with a few plant varieties. He's not only been buying them or licensing them, but he's also been creating his own plant varieties. So that means he's been creating a hybrid, trying to decide, you know, trying to figure out if it's stable, and growing it secretly in the back there. He's also come up with a new trademark himself, and he paid a professional to design the logo, a label for his olive oil products, and also some marketing material.
Yeah, now we've depicted here Mr. Plan Ahead's new product. Hopefully what you see is a new bottle with olive oil in it and a snappy new label. What we see is a bundle of intellectual property rights, and they all present options for Mr. Head. So what we can see here is firstly the olive oil in the bottle. That's produced from a new variety of olive tree. So Mr. Head has the option of filing for protection of a plant patent. The product also has a lovely label on it, bears the word Catto and a cartoon cat, which happens to be the Head family's black cat. Now, potentially they could register the word or they could register the logo or both as registered trademarks. That's an option. It's not mandatory, but they could do that. The new bottle design, the funny shape of the bottle, that could potentially be registered as a design. Pardon me. And they have a new pourer that pops up from under a flip top. Nothing like it on the market. That could be the subject of design registration to cover the appearance, or because it's got functionality, could potentially be the subject of a patent. Now, the front and rear layout of the label, you know, on labels there's usually description and wording of all sorts of important things about the product. That's protected by copyright. Now, the protection's inherent from the moment it's created, unlike patent protection and design protection and trademark registration, where you have to apply for protection. And incidentally, for patent and design protection, you really have to think about that before the product is disclosed publicly and hits the market. They've used or developed a new olive oil processing method to come up with what's in the bottle. Potentially that process could be the subject of patent protection. And they've got confidential information in a wide range of things relating to this product. The know-how in operating the process and how to operate the process machinery, customer lists, supplier lists, additive lists, distributor lists, testing procedures and so on. All valuable stuff that your competitors would like to get their paws on. And finally, the unique overall look and configuration of the bottle in combination with all the features constitutes the getter, and that's valuable too.
So funny you should mention that all of that IP is available for filing registered rights for, because he's actually gone ahead and filed a patent application for the new pouring dispenser on the bottle. And he, quite clever, as you can see, he's got quite a cunning look on his face there. Oops. He has not sold any products or published anything about them before filing his patent application. So he kept his pouring dispenser quite secret before he filed the patent application, which is a great idea. He has not filed a patent application for the new inventive improvements in the method of oil production. He's keeping those secret at this time. And we really love it when people keep things secret before they file a patent application.
We do love good secret.
Yes, very, very important. And we'll talk about that a little bit more. Importantly, he also hasn't sold the oil from the new improvement just yet. He's still selling it using the old method, and we can talk about that in a little while also, but basically he is still working on that and optimizing it. He has filed a design application for the appearance of the bottle, the shape, as well as the pouring dispenser, hasn't he?
Mm-hmm,
Yes.
mm-hmm.
He has not yet filed any applications for the new plant variety. He's first checking if they are stable. And that is, as Carolyn mentioned, a requirement of a plant variety, that it has to be stable through several generations, reproducible. So he's first doing his required testing of that before he files for the plant variety. And then for the ones that he is currently growing, he has contracts in place that he's bought or he has licensed olive plants from third parties who have developed their own hybrids. So this is his plan of action.
Well, yes, he's also, with respect to this whole project, he's had a designer, I think Victoria mentioned that he's had a designer create the labels. Now, wisely, he and the designer have signed a contract, and better still, the contract actually had a clause in it providing for the designer to assign any intellectual property that he created to Mr. Head. Now, this is quite important because obviously Mr. Head is going to want to control all aspects of intellectual property in his product. Please don't ever assume that just because you pay somebody to do something for you, that you automatically own any intellectual property in what they create. It's not necessarily so. it's always much better to have these things down in writing so that everybody is literally reading off the same page. It's also true that copyright assignment has to be in writing to be enforceable in Australia. Now, looking at the trademark, you remember there's the word catto on the label. There's the delightful little cat drawing, which we refer to as a logo. And he could file individually for trademark registration for the word and for the logo, or in combination, perhaps as the entire label. Now, if he was asking our advice, we would say, are you going to use catto or the logo on other products? Perhaps he's got a shop where he sells olives and he wants to put catto on the olives, or perhaps he's going to sell sliced olives and wants to put catto on those. That would become then sort of a house mark that he's using across different goods. In that case, we'd definitely recommend registration. That will put everybody on notice that that trademark is his. And then, of course, he will be able to put an R and a circle on it too, to further flag that it's his. He's planning to enter into agreements with potential distributors, possibly overseas, and we'll get into that a little bit more. But it's handy to be able to point to an IP registration when you're doing agreements like that. And he also intends to sell products through Amazon, so he's really up and about with this.
Wow. So Mr. Plannerhead has been a busy guy. He's one of those people that make you feel like an underachiever, and he knows exactly what he's doing, and he's got a full plan of action. And here's his trademark, and we'll tell you why we think it's so great. Number one is about cats, and we really like cats. For all those dog people out there, cats are great. And plus, this is a particularly happy cat, isn't it? So yes, we like him. So, but what we really like most about this trademark is the fact that cats have absolutely got nothing to do with olive oil. So when you see this mark, it doesn't actually bring to mind olive oil. There's no reason why any other competitor needs to use a cat mark for olive oil. And the only association with this particular mark is with Mr. Head's business. So when you see this mark, you're not going to think olive oil, you're going to think Mr. Plannerhead's olive oil is what you're going to think. The reason he's got the R there is because it's registered. It's a registered trademark. You can't put the R there if you haven't got a trademark registration. So that's very important. If you put the R there without a trademark registration in a particular country, that's considered a misleading statement. So it's much safer, and we'll talk about what to do if you haven't got a registration, but essentially he can put the R there because he's gone and registered it. Normally when people approach us to see what they should be filing as a trademark, we say, well, what are you intending to use? So in this case, he'll be using the word catto on its own in some places. He's going to be using the logo on its own in some places, and he's going to be using the combination. So we would say file for each of those versions of it. So yes, it's quite a unique mark. It's different to all of his competitors' marks, very importantly. It does not include any geographical names, so it doesn't specify exactly where it's from. Mr. Plannerhead can put that in on the rest of his label. There's no reason why you can't explain where your products come from, but he hasn't included it in his trademark. And also what is great is he hasn't used the word great. He hasn't used best or good or improved or better than the rest or anything like that. The trademark examiners at IP Australia, where they examine trademark registrations, don't really like those words, and they will tell you that other traders need to use those words, and if you include those words in your trademark, it can block your application. So he hasn't actually, you can use things in slogans, but rather to keep that out of your trademark. So now we're going to move on to another character who we're quite fond of. He's a nice bloke, and tell you his story.
Yes, this is Mr. Shielby Wright and the Wright family, who have an olive farm, an olive production business. Now, we're not criticising his approach to IP. He's really here to show a different way of dealing with IP and to compare and contrast with Mr. Plan Ahead and his approach to it. Now, the Wright family have been using very old family production methods for olive oil, but just recently they've come up with a significant improvement at the front end of the processing. All deals with a new high pressure nozzle in the cleaning step to reduce the amount of twigs and leaves and dirt and detritus that goes through the process. And it also has the advantage of reducing water usage by half. It's a cracking advantage. And one of the employees' wives is a journalist for the local newspaper, and with the Wright family's blessing has done a double-page spread on the business and the process, featuring it in great detail. The article's been picked up by the Weekly Times, and it's great marketing for the business. They're pretty happy about that. The olive oil sold in standard bottles, you know, those long profile ones with the circular cross section with a nice cork in one end. And they're part of a great supplier deal that Mr. Shielby Wright has worked up. Now, Mr. Shielby Wright has heard that there's a few competitors, such as the Head family, that have been making their product look a bit more flash and have done a bit of a relaunch of the product. So Mr. Wright's hired a professional designer to update the Wright family product. He's asked the designer to come up with a trademark, design a new logo and incorporate it into a label with lots of flash new marketing material. It's a bit of a handshake agreement. They've known each other for years. And the Wright family olive grove is planted with trees that were imported from Italy many generations ago. They're very beautiful, and the designer's taken photos to include in the marketing material.
Great, so let's have a look at Mr. Shielby Wright's product. And so we've got a great picture here of his olive oil bottle. And he's starting to look a little bit worried because he can't see as many arrows pointing at his bottle as Mr. Plan Ahead had, but he's still got some. So let's go through what he has. First of all, let's have a look at his trademarks. So having a look at his label, he's got a wreath of olive leaves and olives. He's got the words olive oil, just in case people can't tell the bottle has olive oil in, but it's good. It's good for identification purposes.
Mm-hmm.
And he's got his trademark. He's called La Aceituna, which, forgive my pronunciation for any of the Spanish speakers out there, is Spanish for olive oil. He's also got the word Bendigo on because he probably comes from the Bendigo region, and he'd like to identify that's where his olive oil comes from. So he has this label. He has a trademark in the whole label. He's been using it as a trademark. The wreath is technically forms part of a trademark, and the words La Aceituna also form part of a trademark. Essentially, he's been using the words Bendigo and olive oil in his trademark, and we can explain a little bit more on that, but there are various components here that are trademarks as well as the entire thing. He also has copyright in the label and the get up and colors and look of his product. And on top of that, he also has his confidential information, which is more or less comprises the bottle supplier information at this point. He has told everybody about his new methods, and he's currently selling the oil that's made from the new methods. So technically that's not confidential anymore, but he's still got a bit of confidential information yet that he hasn't told anybody about. So this is his plan of action. It's a little bit shorter than Mr. Plan Ahead's, but he's still got one. He plans to keep selling his product. He would like to enter into agreements with potential distributors overseas, possibly overseas, in Australia and overseas. He was hoping to actually start selling his product more online. And yeah, he'd basically like to know what he needs to do.
Yeah, so Mr. Shielby Wright is having a think about whether he'd like to register his trademark. You don't have to register trademarks. If you do, the trademark has to be distinctive. Now, just looking at what we have here, you remember that Mr. Planner had the word Catto and the little pussycat family cat logo. Contrast a bit with this one. If we were looking at this, we'd say the chances of getting it registered is marginal. Firstly, because if you look at the words olive oil, well, that can't be a trademark because it's directly describing what is in the bottle. And every olive oil trader will need to be able to use the word olive oil. The word Bendigo, place name, really every trader in Bendigo is going to need to be free to use that. So that can't really distinguish Mr. Shielby Wright's olive oil from any other producer, certainly in Bendigo. Looking at La Aceituna, to many of us it will look distinctive, but in fact in Spanish it means olive oil. And the Trademark Office in Canberra would look at that and say, well, there are a sufficient number of Spanish-speaking people in Australia that would understand that to mean olive oil. That means that you can't really distinguish olive oil. And finally, the wreath, the olive wreath, is not unusual in the olive industry and certainly the olive oil industry. So it's not particularly distinctive. It would be very, very hard to get registered. He also has another small issue, and that is that he had somebody else design all this, and that somebody else technically may own the intellectual property in this trademark. Now, that can be rectified. He might be able to get assignment from the designer, hopefully he can. Without an agreement in writing to do so, it's tricky, but still, it may all work out. He may be able to get an assignment in writing from the graphic designer, and we hope he does, because that would smooth the path very much.
So yes, so just to add to that, copyright is it's governed by the Copyright Act, but also by common law. It is not possible to assign a copyright just by a handshake agreement or just by email saying, here you go, you own it now. It has to be a specific document identifying the copyright and saying that it is being assigned, ownership has been assigned and signed by both the parties. So normally people do agree that they will assign it and then later sign the actual copyright assignment document. So basically that's what he needs from his graphic designer. And he has been doing a good thing here. He's been using the TM symbol. Conventionally, it's up in the superscript in the top right-hand corner. So he hasn't been using an R with a circle, which is great because he hasn't got anything registered, but he's been using the TM standing for trademark. It's quite fine to use that TM even if you haven't got a trademark registered. What this indicates is that you are using that as a trademark. And this may actually help him in the long term, because unlike patents where you have to keep everything secret and you really don't want to use it in public or tell anybody about it before you file a patent application, with trademarks, it can actually help you to be using it. So in his case, he has, although he's only recently been, in competition with his Flash competitors, he's only just come up with this trademark and he's been using it, but he's probably been using it for a few months. So that means he does have some evidence of use, and he has been using it as a trademark as indicated by the TM there. So let's have a look at the comparison of the business assets. So as you can see, Mr. Plan Ahead is pretty chuffed because he's got a longer list. And Mr. Shielby Wright is starting to look a little bit worried because he's not quite sure what he's ended up with. So Mr. Plan Ahead has obviously got his real property, his tangible property, which you'll all be very familiar with on your balance sheets. That'll be your land, your equipment, and any other actual real property that is owned by your business. But there's also the intangible side, and Mr. Plan Ahead has a couple of patents. He's filed one in Australia and one in New Zealand. So patents are governed by each country. It's not possible to have a completely worldwide patent. We won't go into the details of all of that, but essentially you need to file in each country where you are planning to sell your goods or manufacture your goods. So that's why he's gone and filed it in Australia and New Zealand. How it works that Australia signed certain international treaties, so it means that if he files something in Australia, he has 12 months in which to file in the other countries also. There's a sort of buffer period of 12 months, and if he wants to file in, say, the US or China, he can do that within 12 months. He's also filed a design application for that fancy new pop-up pourer, which we mentioned earlier on, and that's for the appearance of it. He can, because he's filed that in Australia, he also has the option of filing overseas trademarks in other countries within 6 months. And he has a plant variety that he's licensed, because he's not yet filed his other one. Mm. He has a bunch of trademark registrations. Now, trademark registrations, they also have this buffer period. They work a little bit differently. So if you file in Australia, you're able to file overseas in other countries within 6 months and backdate it. So you can claim an earlier date. But that doesn't stop you. If maybe 5 years later you decide, I'm actually going to sell products in the US, you can file your trademark there. The only difference is that you can't backdate it. It takes the date that you filed it, but that's fine. So he's filed his Cato trademark in 4 different countries. Importantly, he hasn't started selling products in China yet. He's gone ahead and got his trademark filed there first, which is a great strategy. It's not required. It's not a requirement, but some people have come a cropper in China in that they've sold their products there first, and then somebody who they don't know has gone and filed a trademark application and claimed it for their own, and then tried to sell it back to them. So you definitely want to avoid these kind of scams. If you are planning on doing anything in China, it's always good to get your trademark position secured and registered there first before your product starts getting sold and before somebody can try and pinch it off you. He's also got his copyright all sorted out. He's got his copyright assignments in place, and that is the copyright in his trademark and his labels, and also in his marketing materials. He has common law trademarks, so essentially that's the same trademark that he's filed for his registration, but because we are a Commonwealth and English law and all of that, we have this sort of layered approach. So the common law also gives you rights in that trademark, which underpins his registration as well. He has confidential information and trade secrets. He's got all of his employees have signed non-disclosure agreements. They all know that he keeps his confidential information locked up. Only certain of them are able to access his confidential information. That would be, say, his new methods and his client information. And he keeps that under password protection or lock and key. They all know that they're not allowed to tell anybody about it. And also they know that if they do tell anybody, it will cause him damage. It will damage his business. So that is very important that he has all of that in place, so nobody's blabbing about his secrets. Unfortunately for Mr. She'll Be Right, he has a shorter list, but he still has some things. He has common law rights in his trademark, so he has been using it as a trademark, even though he has not actually registered it yet. There is copyright in his trademark and in his label, in the drawing and the wreath. Unfortunately, he doesn't actually own that yet, so he's still got to sort that out. He still has the confidential information in the bottle supplier information, not so much in the stuff that he did a 2-page spread about.
No.
Not so much in that. Great. So now our 2 characters are facing certain challenges in business. Number 1.
Yes, so our 2 heroes have different lists of intellectual property rights. So what to do with them? Well, it raises the possibility of making the intellectual property earn its keep, so to speak. And you can do that through licensing. A license in general is a permission to do something. And with respect to intellectual property, a license is to use the intellectual property and do things which otherwise would be an infringement of the IP owner's rights. Now, Mr. Plan Ahead, in this sense, for licensing, has more options. He has clearly licensable registrations for patents, designs, plant variety and trademarks, and to a slightly less extent copyright. Things like common law trademarks and confidential information and trade secrets, they're a little less easy to define and therefore a little less easy to license. It can be done, but Mr. Plan Ahead has a lot of options for licensing. Mr. Shield Be Right, not so much. He's going to have to be very canny indeed to cut some clever deals to make the most of what it is he's got. And this feeds into his other problem, which was his grasp on ownership, because he hired a designer, is slightly tenuous. And licensing does rely heavily on the licensor having clear ownership of what's being licensed. It's trite to say it, but you can't license what you don't clearly own. So on balance, I'd rather be Mr. Plan Ahead than Mr. Shield Be Right, but Mr. Shield Be Right is not a lost cause. He's still got options.
Yeah, so to go back to the agreements, the best kind of agreement for anything really is where everything is very, very clearly set out and both parties in the agreement know exactly what they've signed on for. So there's no need to argue about it and there's no need to waste money arguing about it. The more difficult kinds of agreement is where one party thought they were getting one thing and the other party thought they were getting something else. And so now there's opportunity to argue about it because it's not quite clear and waste money in arguing. So when it comes to licensing registered patents, designs, trademarks, this is a very clear way of forming a license or drafting a license, because it is very clear exactly what the other party is getting rights to and exactly what is being licensed. So patents, I know it sounds quite esoteric for people who've not come across them before. They are essentially a document, and the document describes in words what the invention is. And within that document is the four walls of exactly what the invention is and what is being licensed. There's nothing outside of that document that's being licensed unless you specify that in the agreement. Same with a design. A design is a document where you've got a lot of pictures showing the appearance of your product. And so that very clearly depicts exactly what's being licensed. For a trademark registration, you've got a very clear depiction of what the trademark is. And you've only got, if you've got a logo, there's a picture of the logo. There's only one. So one trademark per trademark registration, one invention per patent application or patent, and one design per registered design. When you are trying to license common law trademarks, so essentially unregistered trademarks, it's not possible to license unregistered inventions unless they are secret, and that's a whole other problem. But common law trademarks, for instance, it's not always clear exactly what is being licensed. You have to draft the documents very, very carefully, because he might have been tinkering about over this. So say he's been using it for a year and he's sort of updated and he's got several versions. So what exactly has he decided to license? So that is why the registered rights are so much easier to govern in a license agreement. So now there's the second challenge. Each of them are deciding to expand their operations overseas. So what position are they in and what options do they have? So Mr. Plan Ahead does have his options. He has filed his patent applications in Australia and New Zealand. Within 12 months of that, he can file applications in other countries. Normally we say, if anybody comes to us to file a new patent application for an invention or a design registration for a new design, we say the timing of it, try to hold off as long as you possibly can until you've got as much information as you possibly have. So just about as you're ready to launch, that's normally the time to actually file patents or designs. You've got as much information as possible, and you're also holding off until you need to disclose it, just before you need to disclose it. And this pushes out the deadlines for you. So he can file patent applications in other countries within 12 months. He can file design registration or design applications for registration in other countries within 6 months. And for his trademarks, he can file those within 6 months and backdate them, or he can file them at any time. There's also various international sorts of applications which he could leverage and which he would need a registration for. We won't go into that in detail. His plant variety that he's currently licensed, there might be possibilities of sub-licensing it. He hasn't filed his own plant variety application yet. When he does, that is a peculiarly Australian thing, but he can get plant patents in the US and other sorts of places. So
a few limited ones.
But yeah, that's mainly an Australian side of things. He also has his copyright. Copyright, as we've said before, arises automatically. We're part of the Berne Convention, which means that his copyright is recognized all around the world. So he doesn't have to register that, and it's already attributed to him all around the world. So Mr. She'll-be right at this point doesn't have registered rights, so it's not possible to pursue rights in other countries based on his common law rights. Other countries don't always recognize common law rights in Australia. So at this point, he doesn't have much option for filing overseas. He would have to, he'd basically have to focus on his trademark at this point. Yes. So the third situation.
Yes, the third situation is when the copycats arrive. I think most people who have intellectual property protection have done it, at least in part, with an eye to people who might copy their intellectual property. Now, whoever said that copying is the sincerest form of flattery clearly was not a patent attorney. We just view it as a form of theft. And having your IP copied or being accused of copying somebody else's IP can indeed be, to say the very least, upsetting for the people involved. IP disputes in countries like Australia usually commence with receipt of a letter. It's called a cease and desist letter or a letter of demand or some name like that. If you were to ever receive such a letter or have the need to send one, we suggest your first stop is to consult with a lawyer such as Jackie, because this is particularly true if you're sending one out, because an incorrect assertion in such a letter can actually spring back on you. The intellectual property statutes, unlike most other forms of legislation, include provisions for what are called unjustified threats. If you throw out a threat of legal action based on some action that later turns out to be wrong, in fact, the other party can have a red hot go at you. So for those reasons, we do suggest that you discuss it with a lawyer. And there's other things about letters of demand. Sometimes a formal letter is viewed as overly aggressive, and a more softly approach might be better. Sometimes a polite email will work. A lot of infringers are unwittingly infringing, and just putting them on notice may be enough to make them stop, or it may not. Most parties enter into discussions to sort these sort of things out. Now, if you've watched a lot of television, particularly American legal type series, everybody ends up in court 5 minutes after an offence is committed. Well, in real life, particularly in Australia, is just not like that. The vast majority of intellectual property stoushes don't go to court. They're settled. They've figured out between the parties beforehand.
Yeah, we're just not that exciting, are we?
We're just not that exciting. No. So if you receive a letter of demand, don't worry, you're not going to be in the federal court, next Monday. In fact, you probably won't be in the federal court at all. Now, being able to point to a registered intellectual property right does add a certain gravitas and clarity in any intellectual property dispute. And it can form a type of leverage over somebody if they're copying your intellectual property. Now, the other advantages with having registered intellectual property rights are things like custom seizure provisions. Most countries around the world these days actually have provisions to seize goods that infringe an registered intellectual property right. For example, you could, if you had a registered trademark, somebody was bringing in goods with that trademark on, you could notify customs and potentially have all the goods grabbed at the border. In countries like China, in fact, they will grab goods coming in and going out. They have very strong laws relating to that. That may surprise you, or it may not. The other thing is that we did mention that Mr. Plan Ahead was going to utilise the internet to sell products, or at least advertise products. You'll also be aware that there are a lot of websites out there that advertise goods or sell goods that are knockoffs. The major platforms such as Amazon and Google do have provisions for taking down websites that have knockoffs or invitations to purchase knockoffs. But they usually will only allow you to access those provisions if you have a registered trademark. In some cases, a patent will also do, but they all seem to hinge on a registered trademark. So that's another very good reason why you might want to register your intellectual property, particularly your trademarks. And you can actually sign up for brand registry at Amazon. They're taking trademarks and IP generally very, very seriously. So on balance, Mr. Plan Ahead would have more guns in his armoury if he were to take on an infringer. Mr. She'll-be Right would have a harder path to stopping people copying his intellectual property.
Yes, and then just to add to that, having a trademark registration not only helps you enforce it against other people, but it also helps to defend you against what you're currently using. So having a trademark registration for what you are currently using is an absolute defense against trademark infringement by other people. So if Mr. She'll-be Right did manage to register his trademark and he did get a nasty letter, it would at least hold off the allegations of trademark infringement. It might not hold off the other allegations under other law, which are actually sometimes easier to deal with, but at least it will hold off the more serious one of trademark infringement. So that it would be worth him to having a look at that. But just looking at his confidential information there too, he is in a little bit of a vulnerable position there because your copycats are often your competitors. And where do your employees go, especially if they are disgruntled? They go to your competitors. So a lot of people do lose their confidential information. It travels with their employees who are not always bound by non-disclosure agreements. And this can be a bit of an issue. So it would be great if he managed to secure some of his information there and make sure that everybody signed non-disclosure agreements. But more about that now. Let's talk about how we can actually help Mr. She'll-be Right get a longer list like Mr. Plan Ahead. It's not too late to get his copyright assigned, so there's no particular time limit. He could still go back to the graphic designer, and a lot of them are quite used to having this done. Some of them, despite having worked in the industry for quite a while, are sometimes surprised to be presented with an assignment agreement, but when you explain to them that the agreement that they've signed doesn't necessarily specifically assign it, then they're normally quite happy to sign it. Then we would advise him to go ahead and file his trademark application, even though it's got Bendigo and olive oil in. It might be better if in the future he didn't necessarily do that, but he could basically file an application for what he's currently using. He would then need to provide evidence of prior use, because it is likely that a trademark examiner would look at it and come up with reasons why what we were just talking about earlier, he can't have it. One way to overcome those issues is to give evidence of prior use. And what that does is it shows the examiner that there are people in the public domain, the customers, who already associate this trademark with Mr. She'll-be Right's products. And so there's no reason that they would be confused by his label. Mr. She'll-be Right's not stopping anybody from using the word olive oil or anything. He is just wanting to stop people from using his trademark that he's already developed a reputation in. So that can often get a trademark application over the line. The only thing with that is that there is a bit of a time delay if he is trying to stop a copycat, because the shortest time that he could get his registered trademark is 7 months. So the IP office is not allowed to give you your trademark certificate in less than 6 months. They have certain obligations in terms of overseas treaties. So that's the shortest time. And considering he needs to file prior use evidence, it might take a little bit longer, but it might be worth him actually filing that before he confronts the copycat. If he sends off a letter now saying he has common law rights, that's just a weaker position to be in. If he makes any further improvements to his olive oil production, we would say keep them secret. Make sure that everybody that works for him also keeps it secret. Make sure that they know that it's got to stay confidential, that it's under lock and key, it's under password protection, and that it's only disclosed to people who actually need it in terms of their job, so that they know that they're not going to go and chat about it down at the pub. At that point, even he has further improvements, then he can file patent and design applications. So if he was starting from the beginning, what tips would we give him?
What tips would we give him? Well, we would say, be mindful of the IP that you may have in your business. It's probably more valuable than you think. And because we've particularly emphasised trademarks during this presentation, our top tips for trademarks are, firstly, beware. Don't forget the business name, company name and domain names are not the same thing as trademarks or trademark registrations. Optimally, in your business, you might tie up the same business name, company name, domain name and trademark. That would be good, but it's not necessarily easily achievable. Remember to choose your trademark carefully. It needs to be distinctive to distinguish your goods or services from those of other people. So for that reason, beware of directly descriptive marks. Watch out for geographical names, because other traders in that geographical region have to be able to use that particular name. Watch out for appellations of origin. People in industries affected are usually all too cognizant of appellations of origin. For example, you can't use champagne for sparkling wine made in Australia because, frankly, we are not in the Champagne region. And the same with cheeses and other produce. Don't use descriptive or laudatory marks like fantastic or good or great or world's best. They are not very distinctive. And avoid, like the plague, marks that are the same or similar as another trader. That's just a force for no good. You will run into each other at some stage. Remember that inventive is best. New is even better. And sooner rather than later, consider whether you're going to pursue intellectual property in Australia, particularly for patents, designs, and particularly for patents and designs where you really need to keep your creativity secret until you file the application for registration. And sooner rather than later, consider whether overseas filings are also going to be necessary.
So yeah, also just to go back to how to use your trademark. So first of all, it's good to pick a trademark. Sometimes we have people come in and surprisingly they have the same trademark in 3 different fonts on their product, and they've got their logo on this side of the trademark for the first time, and then on the other side. Be consistent. Pick one form and use that consistently. If you have it registered, you can use the R with a circle. If you haven't, use the TM. Typically, we suggest that there's no harm in putting a TM on, even if you've registered it. And that actually works quite well if you are planning on exporting your products overseas. It means you don't have to have separate labels for these products going overseas and these products that are staying in Australia when you don't have a registration overseas, but you have one in Australia. So usually a lot of people just stick with a TM. Also, if you are using your trademark, it's a very good idea to keep records of use, at least a use at least once a year. This helps you for filing trademarks for ones that you have not yet filed trademark applications for, but it also helps you defend it, because there are provisions for third parties to attack trademarks for non-use, and you always want to be able to prove that you've actually been using your trademark to keep it and maintain it safe. If you come up with new inventions or designs, very important, keep them secret and keep them safe. Don't disclose them, don't put them on your website, don't sell products that are made by new methods, don't sell the products that you've invented until you've decided whether or not to file applications or designs for them. You may decide, it may be your business strategy not to file patent applications or designs, and that's fine, as long as you've made that decision and it's not been made for you by circumstance. It's in that case, then you would keep them as trade secrets and set up your contracts accordingly. So now we come time to any questions.
Fantastic. Again, thank you, ladies. I had a couple of questions that came up for me as you were going through, particularly with plant breeders' rights. I was wondering, and I suppose it might be more under a patent if it was something to do with animal products rather than plant. You know, the light version of potatoes, do they have a patent on that, or a plant breeder right especially for light potatoes?
Oh, I don't know offhand. We can have a look.
We can have a look. Potentially it could be protected by plant breeders' rights. If it's a consistently reproducible new variety of potato plant. Yes. And it produces presumably these low calorie or low starch potatoes. Yes, I think that absolutely would be potentially the subject of a plant breeder's right, and that will mean that the person who owns a plant breeder's right, of course, can sow the potatoes, and other farmers can't come and pinch a sack of them and plant them in their own field. They're prohibited from doing that. If the magic in this light potato actually resides in how they, I don't know, sow the potatoes in the field, that might be the subject of, say, a standard patent, because that's a process. A method of doing something that may be very new. Perhaps they have some magic chemical that they sprinkle over the seed potato. Again, that would potentially be the subject of a standard patent rather than a plant breeder's right.
So similarly then, if someone came up with some cow that was a light cow,
yes,
a light version, I don't know, I suppose you could breed a cow that has less fat content. Is that...
Yes. Yes, absolutely, yes. Animals or methods of animal husbandry are often the subject of patent protection. In fact, people may have heard of Dolly the sheep. It was the sheep that was cloned. Now, the patent doesn't actually say, we claim cloning a sheep. It actually goes down to the molecular level and to the DNA and how the actual reproductive material is handled in a process, and what scientists do to make the cloned sheep. But yes, there definitely was a Dolly the sheep patent, and many other patents of that sort. I think Livestock Victoria pursues a few patents like that.
Okay. Yeah, interesting. And the other one was, I read a book recently, and it was all about the MacArthurs, the people who essentially develop our Australian version of the Merino breed. And just wondering again, I suppose it's not the meat product, it's how it grows its wool and the quality of the wool, isn't it? So
yes.
I'm
sure that there's probably plenty of patents relating to wool and how to grow a better fleece. I know that there were actually a series of patents directed to treating animals so that their fleece didn't have to be shorn off, that it would in fact be able to be pulled off.
Yes, they look horrible, those sheep. They're just horrible looking.
Yes. Yeah, there were a few problems with that because the fleece would just fall off in the paddock.
Yeah.
Which isn't helpful. Or they'd have to wrap the sheep up in a sort of blanket thing to keep the fleece on. So you're using a blanket for the woolly sheep, which is just ironic and weird.
Yeah, so I know, going
yeah,
back
very
to the
interesting.
plant variety side, I would have to look it up again because it's been a while since I've read it, but I know that the Pink Lady apple, they had, that was a bit of a debacle and they kind of missed the boat on a bit of that, but yes, because they didn't get their plant breeders right through, did they?
No.
And then a lot of people are now growing that overseas, and they could have in Australia. I think it was a government sort of funded kind of project, but basically Australia could have made quite a lot in licensing, which unfortunately didn't happen. But yes, we would have advised them differently.
We would have advised them differently,
yes.
but yes, the plant patent register is a cornucopia of interesting things. A lot of fruit.
Okay.
A lot of
grapes.
Grapes,
Yep.
yes, grape varieties. All sorts of interesting things there. Cut flowers, and of course to the nursery industry, new varieties of plants are very valuable. You often go into tulips, and particularly you often go into different stores like Bunnings, and you'll see actually on the swing label they list the plant breeder's right number.
Yep. Quite
Right.
interesting. Yes.
Okay. Wow. There you go. Well, thank you very much. For those watching the replay, of course, questions, please email them through, and it's probably best to either email them to me, Jackie@tbalaw.com.au, and I can get you the answer and we can go from there. So yeah, please reach out. Any generalized questions within reason, and obviously if it's a more specific question, Houlihan Squared and all the people there and these ladies can help you out to guide you as to what next, I guess. So thanks again.
Sure.
Great.
Enjoyed
Thank
it.
you so much for having us.